Joining us now for his first U.S. television interview is veteran, former espionage prosecutor, and former member of Robert Mueller's team. He worked on the prosecutions of Michael Flynn and Paul Manafort. His name is Brandon Van Grack. Mr. Van Grack, it's a real pleasure to meet you. Thank you.
Nice to meet you as well.
First of all, thank you for doing this. I know you don't do this, so I'm very grateful that you've decided to be here. I want to talk to you about a lot of things in your career, but I want to start with the national discourse right now around this investigation involving the search warrant at the president's home in South Florida. The headlines that say this is an inquiry under the Espionage Act are continuing to blow everybody's minds. I still find it to be almost impossible to look at those headlines and not see this as a movie and see this as real life. But as somebody who's actually worked in the nitty-gritty around this part of the law, what should we understand about the seriousness here, and do you feel like any of the national discourse around it is wrong or overblown?
So it's a really important point, because right now there is a focus on what is the end game. Is someone going to be charged? And you don't need to get to that point to appreciate the fact that there is serious national security implications from the conduct and the information just before us. I mean, it's just from the receipt of this search warrant. There are multiple series of documents that are classified, that are labeled top secret, that were in unsecured locations for 19 months. We already know the fact that there were classified documents that were provided to the archives 7 months before that. You don't need to take any more leaps beyond that to appreciate the fact that there's real national security harm and potential damage caused by that. Right now, the intelligence community is sorting through that information and doing a damage assessment, trying to assess what sources and methods have been compromised. That's separate from whether, in fact, anyone is charged. And so it's important that we don't get too far ahead of what's in front of us. One
of the things that's been sort of described by reporters, and I'm not quite sure that I totally understand it, I think I get it in my head, but not in my gut, is that the Justice Department's reference to the potential statutes that are implicated here, I keep hearing it described that it doesn't necessarily matter, that the way they are citing statutory law doesn't necessarily matter if Trump believes that he declassified those documents, that the technical classification status of those documents wouldn't necessarily impact whether or not charges could be brought on those statutes. Do you agree with that assessment, looking at what we've seen in the search warrant? And can you explain it?
Yeah, so I think that might be technically true, but in reality, I think ultimately, if in fact this material was declassified, I think it would have a material impact on whether charges are brought. So the charge referenced in the Espionage Act, it concerns the mishandling and retention of classified information. It's 18 United States Code 793. And the language in the statute says the retention of national defense information. And that's defined through years of case law. It doesn't say classified information. But for all intents and purposes, the Justice Department considers that to be classified information. There's only one case in its history where information that was not classified information was charged, and that was actually a plea agreement. So it wasn't sort of tested. And so for all intents and purposes, if the Department of Justice believes or has reason to believe that this information was declassified, and we don't know that, then it is very unlikely that what's called a retention case, that the retention charge would occur. Now, with respect to the other two charges that were mentioned in the search warrant, there was one concerning obstruction and another concerning the removal of ultimately presidential records. That also doesn't have a connection to classified information. So it doesn't technically matter. But ultimately, the motive and intent behind the removal of the information or the obstruction does matter. And so if people involved in the process did believe they were declassified, that matters. Now, that doesn't mean, and therefore it precludes a criminal prosecution on those two statutes. But the point is, it's matter and it's relevant. And so I don't think simply saying it's immaterial is the right way to view the charges.
If the person in question here, one of the people in question here, is potentially in trouble because of the way these documents were handled, is the former president, is there a way to divine his intent for the purposes of deciding whether charges are warranted without interviewing him?
So the reality is, if he's the target of an investigation, there isn't going to be an interview. I mean, that just, and we do know from the information that you discussed in the top of the hour that there's discussion in the government's recent filing in terms of the decision not to unseal the affidavit, that there are witnesses who are cooperating in the investigation. They specifically say that's a basis for not unsealing the affidavit. So there are certainly people in the orbit that would have information that would be relevant to understanding intent and motive.
One of the things that arose today in the news was a claim by former President Trump that his passports went walkies during the search warrant, during the execution of the search warrant. He described them as being stolen by the FBI. There's later reporting suggesting that these were perhaps that his passports were taken as part of the execution of the search warrant and then returned to him. What should we understand about that?
So a couple pieces, which is first, there's a lot of noise that happens in these investigations. And it's really important that we're not distracted by the cacophony and really focus on the important information. And that goes to my earlier point, which is just based on what we know, there are significant national security implications behind what happened. With respect to the passport, if that is in fact true, if in fact there were multiple passports of the former president taken, there's really not much to read into that. It is unlikely that the Department of Justice is signaling that the former president is a flight risk. It is unlikely that the Department of Justice is signaling that criminal charges are imminent. More likely, again, if it is in fact true, it is simply responsive to the search warrant. The search warrant specifically said it can seize presidential records. And so perhaps the FBI believed, I don't know rightly or wrongly, that these passports were presidential records. There's also in the search warrant, it says information that's commingled with the classified information should be seized. And so for all we know, these passports were commingled. But talking about something that ultimately I don't think is significant, if for any reason the denial of these passports impaired the president's ability to travel, I'm certain that a simple call from the president's lawyers to the Department of Justice would resolve that. So ultimately, I think it's a distraction, and it's important because there are some real serious issues here that we don't get distracted by.
I think it's one of those things where it's like you see, the government has his passports and you immediately go to like the issue of Law and Order where the guy gets arrested and his passports are seized because he's seen as a flight risk, but there's nothing here to indicate that kind of connection.
And look, there are instances where passports do get seized, but that is when someone is about to be charged or has been charged. And there's no indication that we've reached that point in an investigation.
I also wanted to ask you about the news reported in the New York Times this weekend that President Trump, through an intermediary, appears to have tried to reach out to the Attorney General after this search warrant was executed, obviously, and after the Attorney General, around the time the Attorney General was making his decision to both speak publicly about it and to ask for the search warrant to be unsealed. Just from the perspective of somebody who's in the Justice Department at the kind of levels that you worked at, is that wrong? Is that weird? Is that appropriate? Is that normal? How do you view that?
I guess I view it as irrelevant.
Okay.
The reality is there are probably outreaches that occur to senior levels of the government, Department of Justice all the time. This is something where I cannot see or think of a situation where an outreach like that will have any impact on the investigation. And so appropriate or not, again, I don't think it will have any impact on the investigation. And again, really, I would consider it to be noise or a distraction when the fact is, again, there are real national security issues at play, and that really should be the focus.
Well, let me ask you about another thing, which may just be a distraction, but from the outside, it seems at least fraught. We've now seen 3 Trump White House lawyers, the White House counsel, Pat Cipollone, his deputy, Pat Philbin, and now today we learned Eric Hirschman, all White House lawyers working for the president, all having received subpoenas from the Justice Department. We don't exactly know the topic. We don't know which grand jury. There's a lot of different investigations. That itself is remarkable. We've also seen a member of Congress had his phone seized as part of an investigation in which he reportedly has been told he's a witness and not a target. When you're talking about White House lawyers and serving members of Congress and these sorts of people who aren't typically caught up in the work of the Justice Department, how does that influence you, your decisions as a prosecutor, as an investigator, knowing that people with a lot of political power and people working in sensitive political jobs are in your sights? Well,
I think one of the signals from the Attorney General and the Justice Department, which is really important to stress, is that ultimately those considerations really are not having an impact. And that's in multiple investigations. In fact, I think there's also reporting today indicating that the search warrant with respect to Mar-a-Lago was sitting with the Attorney General for a period of time and that he was wrestling with it. And I think what we can say, even though I think it's common for there to be disagreement in some of the actions from the Department of Justice, that all of the actions we're talking about are not influenced by political considerations. And there really is no appearance of political influence in these decisions. And I think that is such a critical issue for the Department of Justice. I mean, really, if you take a step back and appreciate when you talk about the Department of Justice, it is foundational to the legitimacy of the government to exercise its authority. I mean, it is a department that has the ability to deprive an individual of their liberty. And so the legitimacy of that department is paramount. And I think the Attorney General not only appreciates that, but you can see through his words and deeds that that is a constant theme in how he acts.
Brandon Van Grack, veteran prosecutor from the U.S. Justice Department, member of Special Counsel Robert Mueller's team. Again, this is your first U.S. TV interview. I hope it will not be your last, even with me. I hope you'll come back.
Absolutely.
Thank you. Thanks for your service.